Trusts have been taking a lot of flack lately, or at least trust reporting has been taking a lot of flack lately. The Department of Finance decided to change the trust reporting rules, announced it a few years ago, and then have continued to update it, and then finally passed the legislation to be effective for years ending after December 30th, 2023. So a lot of trusts that previously didn't have to file trust returns now have to file trust returns, and they have to disclose a lot of information about the parties to the trust, the settlers, the person that established the trust, the trustees, that's the people that control the trust and the decisions of the trust, as well as the beneficiaries and contributors to the trust or protectors of the trust. There is a wide range of people involved that may have to have their information disclosed on an annual basis. Beneficiaries being the largest group, because that often can extend through the lineage. It can be often in the case of a family trust related to the business, it often includes the children of the business owners, perhaps spouses, perhaps corporations own them. Sometimes extends as far as grandchildren, great grandchildren, if they use the language issue. So I think it's a matter of trying to determine who the beneficiaries are and if their information has to be disclosed. So getting a lot of questions. Well, should I still have a trust? And that really depends. I think there still are a lot of useful reasons to have a trust and a lot of different type of trust that might be applicable in different situations. So if you look at the standard family trust that a business owner might have, often gets set up during an estate freeze. So the owner has decided that they've established enough value in their own hands individually, so they freeze their interest and introduce a family trust so that the future value can grow to potentially different family members. Often it's a discretionary trust. Sometimes the original business owner is a beneficiary, sometimes a spouse, sometimes children, grandchildren, etc. So then one of the benefits is if it's what's considered a qualified small business corporation in Canada, different beneficiaries might be eligible to use their lifetime capital gains exemption, which is over $1 million in 2024. So if the business sells for multiple millions of dollars, there's a bunch of potential tax-free money to the beneficiaries. So still a great purpose there. Um, Trust used to be a useful tool for the business owner for income splitting. There were some tax on split income rules, the TOSI rules, implemented in 2018, which does limit the ability to split income for those that aren't involved in a business, but still can be a useful tool if there are beneficiaries of the trust who are involved or have contributed to the business. And again, still the ability to split the capital gains if it's a qualified small business corporation. There's still income splitting tools as well for non-corporate trusts too. So there might be other discretionary family trusts that someone has loaned money to the trust and they're taking back interest at a prescribed rate. But if the income generated by the trust exceeds that rate, then that gets allocated out to the beneficiaries for income splitting purposes. So there are some tax benefits still, as well as the fact that a trust can defer decision making. So again, if we look at the business owner's standpoint, the business owner might not be ready to pull the trigger on passing the business on to their children, but it might be in their sights in the next few years. Up to 21 years, a trust has a rule where every 21 years, assets of the trust are deemed disposed of, deemed realized. So they could be distributed out of the trust tax-free before that, or the trust could face that deemed realization, potentially pay tax if the value is increased at that 21-year anniversary. So provides a deferral on decision making up to that point. As I said, the trustees can make the decision to roll the assets of the trust out on a tax deferred basis to the beneficiaries. So if we're looking at shares in a corporation, perhaps the owner's child is not ready to take over the business yet. Maybe they don't know which child it's going to go to and they want to make that decision down the road. Or perhaps the owner is going to take some of that interest back themselves and the trustees have the opportunity to make that decision. It is important that you do establish proper parties to the trust. I'm not going to get into details of that, just sort of talking about the use of the trust, but the trustees are the decision makers, so they are the ones that help make that decision down the road. If we look at other types of trusts, one that I commonly deal with, or a couple types, would be alter ego trusts and joint partner trusts. An alter ego trust is essentially an extension of an individual, and a joint partner trust is essentially an extension of a couple, and those are for individuals over age 65 they can transfer their assets, their investments, for example, into a trust. And instead of being governed by their will when they pass away, instead the assets are governed by the trust agreement. So in provinces where there's probate or estate administration tax, that wouldn't apply because the will would not have to be probated. Instead, the decisions are made in the trust agreement where those assets are going to go. So that can be up to 1.5% in Ontario as an example. And it provides a little bit additional control as well beyond the grave. Like a will, it's sort of a lifetime, or decisions can be made in the lifetime, but they can be made for after the individual passes away too, to provide a little bit more control of the assets and a little bit more protection than owning those assets individually. So still a great use for that type of trust as well. Spousal trusts as well are a useful tool. I'm thinking about testamentary spousal trusts. So a common time that a spousal trust might be a useful technique is in a second marriage, even in a first marriage. But an example of where I would see it commonly in a second marriage is if an individual would like their children to be the beneficiaries of their will. They have kids from a prior marriage, and their spouse has kids from a prior marriage. So instead of all their assets passing directly to their spouse when they pass away and then being governed by that spouse's will, and perhaps their children not getting any of the assets, a testamentary spousal trust could be set up. In that situation, an individual's assets are governed by a will, so it goes to a spousal trust. A common situation is that the spouse gets to use those assets, use a house, for example, use the investments in their lifetime, draw on the income or the capital of it, but or perhaps no capital. It depends on the provisions of it. But then when that spouse passes away, that trust document governs where those remaining assets, the residue of the estate perhaps is what it would otherwise be, but those remaining assets go. So it could be split evenly and avoids the ability for that spouse to change where it's going to go. Those are just a few examples of where trusts are still useful tools, but I would say a lot of the useful techniques that trusts provided before still remain in place. It's just an additional tax filing obligation each year. So there could be an additional cost, additional administration, but it really is worth weighing the cost benefit of it. Do the benefits that you were previously seeking still apply? What's the value of those benefits? If it was, you had $500,000 worth of assets, I suppose, in a alter ego trust, and the probate on that at 1.5% would be about $7,500. How much longer are you going to live? Does it make sense to pay someone to assist you with the trust return every year? There's a bunch of cost benefit you have to do on it, and it really depends on the situation. But I think trusts still are a super useful tool. I'm still a fan of them, and I wouldn't let the changes in the legislation scare me off using it in an estate planning situation.